We're hearing a lot about the 558 process, which is a specific requirement in Florida for claims involving construction and design defects. But let's talk a little bit today about how you approach the 558 process, whether it's from the owner's perspective or the contractor's perspective. Hello everyone, this is Chip Bachara with Bachara Construction Law Group, and with me again today is my partner Hugh Higgins. Hugh runs our St. Petersburg office and I'm here in Jacksonville. Today we're going to talk about claims that have become ubiquitous in Florida, and those are condominium type claims, the damage claims from homeowner associations, condominium associations, and so forth. Most of the time they involve water intrusion through the building envelope, whether it's the windows, the flashing, the stucco, the roof, or whatever that may be. But with Florida's weather, that can pose a serious problem and leave you exposed as a contractor or a trade contractor. So today we're going to address what you do when those claims come about. So first of all, for the past, I don't know how long it's been, since the 1950s, certainly, Florida has been a tremendous draw for folks coming in from the north, from the harsh winters, and we provided a great respite from that type of weather. And condominium living has become a way of life here, and especially along the waterfront, whether it's the Gulf or the ocean or in the Keys. That leaves buildings exposed to high winds and really tough weather conditions. And so with those conditions come some breaches in the building envelope, and what follows frequently is a lawsuit. So let's talk a little bit about how those lawsuits come about.
Typically an association, at that point the developer turns over the association to the condominium unit owners. At that point in time, a turnover assessment is conducted by an engineer, and quite often those turnover assessments yield construction defects, warranty issues, ranging from things that could be very small, easy to resolve issues, up to water intrusion or structural issues. And when the association receives that turnover report, then it has a decision to make. Is it going to be able to reach out to the developer and the contractor and obtain some additional punch-out work or warranty work? Or is this going to ultimately result in some form of complex litigation? And in Florida, we have a statute known as the 558 statute that requires, before any lawsuit is filed, that the association prepare a list of any construction defects and notify the developer of those defects and give it an opportunity to correct them before litigation begins.
Yeah, and so talking a little bit about 558 and why it's called 558. Back in 2003 and 4, it took a couple of years for this process to evolve, but the Florida legislature tried to correct a problem that contractors were complaining about. What was happening was the owners, whether they were developers, homeowners, whatever they may be, tended to have this practice of holding the last draw. They wouldn't complain about very much during the process of construction because they knew the contractor had greater leverage in negotiating during construction. But at the end of the project, when the contractor has completed everything, they have little leverage. And then the owner has all the leverage with that final draw. And so as a consequence, Florida adopted a law very similar to what Georgia had at that time and still does have. And it became Chapter 558 of the Florida statutes. Hence, we have the 558 notice, the 558 law, which does, as you pointed out, requires an owner provide notice of a defect, whether it's to the contractor, the architect, the engineer, and an opportunity to it used to be the opportunity to cure. Really, it's an opportunity to inspect. But it does give the contractor a great opportunity to go find out as much as they can find out at the job. And the contractor and subcontractors should be very proactive in responding to a 558 notice that comes from an association in the example we're going to use. So Hugh, how does the association go about putting together a 558 notice?
That's almost always done in tandem with the law firm and with the inspection engineering company that typically is going to prepare a report that itemizes all the construction defects and any resulting damages or problems that are flowing out from the construction defects. And then typically the association lawyer will work together with that expert to determine what defects need to be notified to the developer or the contractor, and will then package up a letter that will attach the engineer's 558 report, as we call it, and refer to it and essentially incorporate it by reference. So rather than the law firm writing a detailed letter that repeats everything that the engineer has identified, they simply give the bullet points, giving the heads up, as well as the specific statutory requirements that need to be complied with by people who receive the 558 notice. So it's no secret that insurance is the critical piece in this space. Associations are making themselves whole and satisfying their claims based primarily on insurance dollars. And so in order to recover insurance dollars, you have to trigger insurance coverage. And insurance coverage is triggered by explaining that a particular construction defect isn't just damaging that specific scope of work, but it's causing some property damage to some other thing. So for instance, the windows are leaking, therefore there's water coming into the building, damaging drywall, damaging perimeter framing, damaging building envelope components, etc. And so that is a very important thing to explain in the 558 notice and in any subsequent litigation, because that's going to tell the insurance company that the policies for the contractors are on the hook for coverage.
A lot of times you may want to measure whether or not it's worth it to bring that in and hold up the litigation late in the process, or if it's just not worth the amount that it may cost to stop that. You know, we've talked about the fact that the real focus is on the insurance dollars, and the way I like to explain it is, you know, the association, their team, they're looking at the low-hanging fruit, so to speak. The low-hanging fruit is the insurance money. Coming after a contractor and trying to get into the contractor or the subcontractor's accounts, checking accounts to collect money is a very difficult process. And sometimes the money just simply isn't there, but the insurance money is. And so that's why the association wants to tailor their claim so that they, as we call it, plead into coverage as opposed to pleading out of coverage. You want to make sure that you've addressed that correctly.
Yes, absolutely. There's a 60 to 120 day process based on the number of parcels. So with the typical condominium association, you're going to be exceeding the threshold, and the 558 process is 120 days. Once that expires, a lawsuit can be filed. Technically speaking, lawsuits are filed somewhat frequently before the end of the 120-day period, and presently there isn't much of a sanction for that. That's just one of the things about 558. It lacks some teeth. It has a lot of great language, and it has a great prescriptive formula, but there isn't a whole lot that can be done when it isn't followed to the T.
So we've covered a lot today, and we know that these cases involving construction defects, design defects, and so forth are not coming to an end, and they require a great deal of expertise. If you find yourself in those situations, if you need counsel, if your trusted counsel maybe doesn't have the experience in construction law that you feel like you need, give us a call. We'd be glad to help you and help walk you through it and perhaps become your trusted counsel for your construction matters.